We're going to get started. So first of all, let me welcome the people who are here live. And according to those who signed up, I think there's close to 50 participating online. And that's just a sign of the times. You know, I happen to teach over at the BU LLM program. You got 30 people online and about 10 people in class. So this is the way it is. And if anybody drove into Boston today and got stuck in marathon construction traffic, I understand it. So first, a little bit of advertising. This is an open meeting presented by the Estate Planning, Trust and Estate Administration Group, which is a subcommittee of the Real Estate Bar Association. We're in our second year, and we're looking for volunteers. We're looking for volunteers because the board thought it was a good idea to bridge estate and trust attorneys with real estate conveyancers. They're two separate disciplines, and there isn't always a lot of communication between the two, but there's an awful lot of things that happen that involve both trust and estates as well as real estate. Some of the projects that are pending before our committee, which is not a very substantial committee, would be the spousal share statute. There's a comprehensive spousal share statute that's making its way through the legislature. There's a provision in it that has a 1-year look back, actually a 2-year look back, so that when one person dies, to determine how much a spouse who's been excluded can recover, you take his assets and her assets and you add back assets they gifted. You multiply it by a percentage based upon the number of years marriage, then you multiply it by 50%, then you subtract her. It's a bit of a nightmare, and we develop a position. Are we going to be in favor, opposed, or neutral? You have some legislation now. It's estate recovery as against life estates, a topic that we're going to talk about today. Massachusetts tried this a few years ago, and then it was repealed. Well, it's back making its way through the legislature. So our committee is charged with developing an opinion. Are we in favor? Are we opposed? There are homestead statutes that are making their way through the legislature to expand the definition of an owner to include perhaps a remainderman, life estate. We'll talk about that today as well. So there's a lot of exciting things going on. Right now, it's a committee of basically two, myself and Miriam. So I'm going to encourage anybody who's here or listening who might be interested in helping us develop positions, influence legislation, respond to cases, to get involved. And we'll probably have a half a dozen meetings a year, but you can really get active and do an awful lot of good. So that's a little bit of a plea. We try to find topics that are unique. Today's topic is life estates, a property interest, or an interest in trust. This is a classic case of a real estate issue conflicted with a trust issue. You know, we as trust lawyers don't think of a life estate as an interest in trust. And we don't think of a trust provision that says someone has the right to live in property as a property interest. And the reason for this program today is because of a decision that came out of Worcester Superior Court, December 23rd, 2015. And I'll give a brief introduction, then I'll turn the podium over to Todd, who's probably done as many Medicaid cases as anybody practicing in Massachusetts, both planning in advance, last minute, and then fighting with the government on appeals. But I'm just going to give a brief overview. And what's frightening about this case is that it involves a planning technique that virtually everybody uses. So to keep it real simple, we're going to have a parent who creates an irrevocable income-only trust. And there's been a number of cases where these income-only trusts have been attacked, and they were attacked successfully by the government. The case that this court, the Daly Court, relied upon was called Doherty. Now, Doherty was a case in which property had been transferred to an irrevocable trust, there wasn't even a life estate retained in the deed in Doherty. And so since Doherty, the practice has developed where if you're going to create an irrevocable trust to protect the assets from the cost of long-term care, and you transfer real estate, your home, to it, instead of just putting the property into the trust, you would record a deed, transferring the fee to the irrevocable trust, and reserve a life estate. And the thinking is that a life estate is a property interest. As long as there isn't anything else wrong with the trust, there's no way the division could find that the home was available to the transferor according to the terms of the trust. But that's what happened in Daly. Deed to the irrevocable trust, life estate, undisputed that the applicant for Medicaid lived there as the life tenant would. But this particular court found that, quote, if a Medicaid applicant can use and occupy her home as a life tenant, then, this is on page 2 of the material, then her home is available, citing Doherty. But Doherty didn't even involve a life estate. And so, being sort of off the wall myself, I thought it would be a good time to put together some new material, hot off the press. Life estates, a property interest, or an interest in trust. Now, in the Daly case, there was a motion to the judge to reconsider, which was flat out denied. You know, our conclusion today is that a life estate is a property interest, but a lot of good that's going to do, because now we have basically a Superior Court decision which concludes that the retention of a life estate is essentially a right for the property to be available. We think it's wrong, but it is what it is. So, but today we're going to talk about Medicaid planning, life estates, and in general. And so what I'm going to do is I'm going to turn the podium over to Todd, who's going to take us through some Medicaid regulations that, in our mind, make it absolutely clear that a life estate is a property interest. Like, what happens if the property is sold? Who gets what? Where do the proceeds go? But again, the big picture is the client wants to protect assets from the cost of the nursing home. They've created an irrevocable trust. For purposes of our discussion, we're going to assume that there's nothing in the trust that would make the assets countable. Now, in the Daly case, I will say that the court also found, in addition to the life estate, that there were certain provisions that were found to make the property available. The right to reacquire and so forth. But today is not a course on Medicaid planning. We're just going to assume it's a well-drafted, irrevocable, income-only trust. There is no way that principal can be allocated to income. There is no provision for the trustees to loan money to the grantor. There is no power to reacquire trust assets by substituting property of an equivalent value. For anybody out there listening to these terms, they know exactly what I'm talking about. That we're going to assume that the grantors are not trustees, because they've even said that if the grantors are trustees, their ability to receive compensation makes the trust assets available. They are very creative and very aggressive. But we're going to assume that there's a properly drafted, at least based upon today's law. You know, I always tell people, my favorite joke is, you know, how do you sleep at night doing this? And I say I sleep like a baby. I wake up every 2 hours screaming. And that's not far from the truth. But we're going to talk today. Todd, tell us about life estates and the Medicaid regulations. What is the gift? Sure. Step up in basis. Thank you, Todd.
And I do think Leo's right when we talk about the life estate being a property interest and not an interest in trust. As we explore even the rules of Medicaid, that will help us make it clear that it is really a property interest and not a interest in trust. So let's begin with what it is. What is the definition of a life estate by the Medicaid regulations? Well, they say that a life estate is established when you transfer the remainder interest in the property to someone else, and you retain the right to live there, the right to use and occupy, they use language like that, the right to obtain income or profits from the life estate interest. That's how you define a life estate interest.
The regulations define that.
That's how the
Medicaid
regulations
regs say that.
define that. And they go on to say that there are no fiduciary obligations retained by the life tenant. Okay, so no fiduciary obligations, which is very different than when you start talking about a trust. And I am going to try and follow along in the material for you. I'm on now page 4, and I'll try to take you through and let you know where I'm at. When they talk about a trust, which it always strikes me as strange when I'm meeting with a client, they'll come in and they'll say, oh, you know, I did some planning before. I've got a life estate trust. And I never knew what that word meant. But it is not a trust, it is a property interest. And when you talk about the Medicaid regulations, they say, what is a trust? They say a trust is a legal device satisfying state law in which you transfer assets, property if you will, into it, and it's now in the hands of a trustee. And a trustee has the fiduciary obligations to maintain, manage that property for the benefit of the grantor or others. That's really what a trust is. And so by definition, the absence of a fiduciary obligation by the life tenant will mean that it is not a trust. A life estate is not a trust. It's a property interest. They go on to say what it is. It's a property interest just like any other property interest. When I say that, like a tenant in common, or a joint tenancy, or the tenancy by entirety, by entireties. These are property interests just like a life estate interest. They go on to say that as a life tenant, you have the exclusive right to possess the property. The remainderman does not have a possessory interest and cannot possess the property until the life tenant has died. So they're really making it clear that you have this possessory interest. Now, I'm flipping over to page 5 because I want to tell you how Mass Health has sort of added to the clarification, because now we're going to start talking about how you value this life interest, this property interest as a life tenant and as a remainderman. Mass Health issued a memo telling us in December of 2007 how to calculate the value of a life estate and how to calculate the value of a remainder interest for Medicaid purposes. Now, what I mean by that is lots of times what people would do, like was described here, we would take the property and transfer the remainder interest away, whether it be to a trust or to the children, and you would retain that life interest. Well, when you make that transfer, that needs to be valued. That remainder interest needs to be valued because it creates a disqualification period for Medicaid and eligibility purposes. So they need to come up with a way to value it. And here's how they do it. This memo explains that we're going to use the 75/20 tables to come up with the interest rate in effect on the date, the month of the transfer. And I'll also explain the month of the sale when we get to it. And they tell you then to take that interest rate and go to table S, which is a single annuity life based on the life tables of table 90 CM. So once you get to the interest rate, you then flip through these table S's until you match the table S with the interest rate that you discovered at 75/20. Then you go down the column for the age of the individual. Find the age, then you go across and you find the remainder value, it's a percentage, and the life estate value, again, a percentage. And that's laid out for you on page 5. as to the procedure that they take you through. What I want to do is give you some examples. We have example A and example B on page 6. Let's run through how this would actually play out. In our example A, we're using June of 2005 as the applicant deciding to transfer his remainder interest in the property to the children while retaining that life interest in the property. The individual is 75 years old at the time, and the value of the property is $250,000. This can be, for Medicaid purposes, the assessed value, whatever the town says it's worth. We don't actually need an appraisal or a fair market value to do this. So it's $250,000. We then take and find the tiger tables, if you will. That's where you can go to find your 75/20 rate that is in effect in June of 2005, and back then it was 4.8%. So then you take the 4.8%, you go to the table S till you find 4.8%. Down we look for the 75-year-old person. Across we go and we find the remainder interest value. 0.6257 or 62.5% is the value. You then take the $250,000 value, assessed value in this case, and you multiply it by the 62.5%. And you come up with $156,437. As what? As the value of the remainder interest that was given in this case to the children, which could have very easily been given to one of these Medicaid irrevocable trusts. Same way. What that means is we now have the number we need to calculate our penalty period. And that's why the state, Massachusetts Medicaid, has come up with this formula to tell us that now you would take $156,000 and you would divide it by what they call the average monthly cost of nursing home care in the state. That today, it by the way changes every year, that today happens to be set at $9,300 a month. So you divide it out and it would give you the number of months that you would be disqualified for Medicaid purposes. So we can start seeing how they're calculating it, which again is playing into the conclusion that what they've retained is a life estate interest in property while they gave away a remainder interest in property, not a life estate interest in a trust. Let's look at example B and figure out how this might play out when you're dealing with the sale of property. So in this case, on the bottom of page 6, we have an individual in August of 2007 sold property for $300,000. That's the sale price, so we don't have to go get an appraisal, that's the price. The individual in this case is 80 years old. Now, as we know, the older we are, the smaller the value of the life estate interest that we retain. So at this point, we take the August tiger tables, go to the 75/20 rate, find August 2007, and at that point it was 6.2%. We again would go to table S, find the table S corresponding to 6.2%, drop down for the 80-year-old individual age, go across, and we come up with the life factor. The life factor is 0.36418 or 36.4%. So we flip the page, and on page 7 we see $300,000, the value of the property, multiplied by 36.4%, the life tenant or valuation number, and we come up with the $109,254. What is that? That's the value of the money, the proceeds received by the life tenant. The difference is distributed to the remainder property holder, whether it be an irrevocable trust or the children, whoever got it. So that's where it would play out. So now we've calculated how to spread out the proceeds from the sale. What are the actual income tax consequences associated with that transaction? Excuse me. Well, in this case, you are able to then allocate the basis of the property in a very similar fashion, using the same code or the same tables. In fact, Revenue Ruling 71-122 tells us how to do that. So in this case, with the individual life tenant receiving $109,254, they would have also been allocated 36.4% of the basis, whatever that basis is. Now, you take the $109,000 minus the basis, and you come up with the capital gain. Now, the nice part about a life estate is, as a present owner, Code Section 121 of the Internal Revenue Code tells us that you get to utilize your capital gains tax exclusion, life tenant. Why? Because you are the possessory owner of that property, and supposedly you then would have owned and used it for 2 of the last 5 years. You get to take your, and if it's a single person, which it is in our example, you get to use $250,000 of your capital gains exclusion, which in this case clearly would result in no capital gains tax regardless of what the basis is that was allocated to them. Now, for the remainder, they would have gotten the difference in the basis and the difference in the proceeds. They would have a capital gain, and likely if they do not live there, then they would not be entitled to the capital gains tax exclusion. We've said that they don't have a possessory interest, so likely they're not going to get the capital gains exclusion. Now, you can argue that if they have a present right to sell the property, which they do, then maybe it can result in that, but we don't know that. So we're going to say no on that. Next, that's the income tax ramifications of the sale. Next, we get into Mass Health looking at a house, a primary residence, as countable or non-countable on its own. Mass Health has a regulation that says your home is non-countable generally. Even if you're a single person like we have in this example, and you move out of your house, as long as you check a box that says I intend to return home when I'm applying for Medicaid, the house would remain non-countable, unless it's worth more than $828,000. I'm on the bottom of page 7. This is a number that started out as $700,000 or $750,000 in Mass. And it's been indexed over the years since 2006. We're at $828,000. There is an exception if you happen to have a spouse living there or a blind or disabled child, then the house can have an unlimited value. But we don't. We have a single person, and so how does this life estate actually help us in the planning world when you're dealing with an $828,000 home or more? If the house is worth more than $828,000 in equity, they would simply tell you when you apply for Medicaid, and it's this powerful, you're denied, don't bother applying. Okay, well, let's change the facts a little and say that this house that we're dealing with in our example is worth $1 million. If it's worth $1 million and the life tenant has a interest in it, going back to our example, 0.364% or 36.4% is their life tenant interest based on how Mass Health tells us to value the property. What would be their value for Medicaid application eligibility purposes? Well, 1 million times that percent, you get $364,118 as the value of what it is they own, their life estate interest in the property. Wonderful. That's way less than $828,000. So in this case, she could actually, or the individual here could actually have $1 million property and apply for Medicaid, and the house would be non-countable, even though it exceeds, the total value exceeds $128,000, because their interest doesn't. So it's actually a wonderful planning tool. But again, it all goes back to the fact that Mass Health has defined this to be a property interest in their regulations in more than one place. And that's what I think we're drawing towards our conclusion, that this is a property interest and not an interest in trust. Let's talk a minute now about Mass Health Estate Recovery, something Leo alluded to earlier. What is Mass Health Estate Recovery? Mass Health wants to be able to recover against assets that you die owning in your own name after you've been on Medicaid. So they can get what reimbursed for what they paid on your behalf. Example, like a house. If the house happened to be non-countable, which we prove that it is, they're still going to put a lien on that property even though you're eligible for Medicaid if you have no other assets. And that lien would then be exercised against upon your death to pay back the state. However, current Medicaid regulations define the ability for the state to recover against assets that are in your probate estate only. Well, a probate asset is an asset that you die owning in your own name. A life estate does what when you die? It expires, it extinguishes. And the remainder interest gets the property and fee 100%. And it avoids probate. So Medicaid, while they will have a lien on the property while you're living, in case I say you're foolish enough or have to sell the property, they would want to get their piece at that time. But if we don't sell it, that lifetime lien expires. And they have no ability to put that at death lien on the property because it's not there. And it's not a probate asset. Well, what federal law says is that the states are allowed to implement the federal Medicaid laws in a way that allows expanded estate recovery. New Hampshire has done it. Massachusetts tried. Back when I believe Mitt Romney was in office in 2003, he tried changing the laws to expand estate recovery to include assets saying any interest you had in property immediately prior to your death would be includable. Oh, well, what would that capture now? That would capture joint tenancy. That would capture life estates and other interests with designated beneficiaries. And certainly revocable trust interests. We don't know about irrevocable trust interests. Well, that's what exactly is trying to be done now in the fiscal budget for this governor, 2017, which, if it passes, would be effective on July 1, 2016 for everybody who applies for Medicaid after that date. And again, trying to expand estate recovery in that same fashion that was done or attempted to be done prior. The good news is that in 2004, when Mitt Romney tried it, it was overturned by legislation. And even though Mitt Romney vetoed that legislation, it was overruled with a 2/3 vote by the Congress. And Massachusetts NALA chapter and others are very much opposed to this. So we'll keep you in tune.
Quick comment, that legislation was effective for 1 full year.
That's true.
You know, it was like the legislature woke up on July 5th after a big celebration on July 4th and realized what they had done. Took them a year to repeal it. In the meantime, the Commonwealth had been happily collecting money through non-probate assets. They actually had a refund money they collected because it was repealed retroactive to the effective date. And what's interesting in New Hampshire is you're actually supposed to figure out what the value of the life interest is the moment before death. So in our example, if we had $1 million property and the applicant was 80 years old, you know, that interest, 80 years old I should say, when the person died, there's $300,000 at risk. So, you know, if this passes, it's really going to put a damper on using life estates as we've used them in the past. But again, a little bit of solicitation. This is legislation that REBA will likely be opposing, but as part of our committee, if anybody wants to help us out, we welcome your assistance. But we see no reason why it shouldn't be opposed from a REBA point of view. And so thank you, Tom.
And now, yeah, go ahead.
Let's assume your kind of second example where the property subject to the life estate is sold.
Yes.
And that produces some cash.
Yes.
Cash is below this $828,000 magic number. Unless that person, unless the grantor, the person who formerly held the life estate, puts that into some sort of an asset, let's say a joint account or a transfer on death account or something, if that asset is in their name at their death, that's a probate asset, right?
It's a great question.
We just have to repeat all
Yeah.
the questions because of the people online. That's the one thing they wrote in big letters for me here, so.
So let me try
repeat
to
it.
repeat that. The question is, in our example where we were selling the property, in which there was a life estate attached and a remainder interest, and when the individual sells it, the piece of the money that they get, we can flip back there and look at the number. I believe it was about $109,000 in our example when they sold it, right? So their life interest would be that. The question becomes, if it was sold, I'm assuming this individual was already on Medicaid. Is that part of your question or no?
You assume both ways, actually.
I'll assume both ways. Either they're on Medicaid or they're not on Medicaid. What would happen to that $109,000 going forward under either approach? Well, here's the answer. If you were on Medicaid already, we would really, really stress to not sell it. Because just tell the children, please maintain the property, pay the bills, pay the heat, maintain the property. Why? Because if you sell it, that $109,000 that the Medicaid individual would now receive, remember that lien, that lifetime lien we just spoke about? That would likely be on the property. And they're gonna wanna now take that $109 to pay them back for what they've already paid. Okay, so please don't sell it, or otherwise that would happen. The other approach would be, what if they haven't gone on Medicaid and they just wanna sell their property? Well, they are gonna end up with $109,000, and if they do nothing else, that is an asset. And to the extent you apply for Medicaid in the future, and you have more than $2,000 in assets, you will be denied Medicaid. So it would be considered a countable asset. Actually, by selling the property, you're converting a non-countable asset into a countable one. Does that help?
Yes, thank you.
Yeah, you really try to discourage people from selling it. And another good reason is, what Todd will talk about now, is the stepped up in basis on death.
Yeah.
It's like giving free money away.
You're creating these taxable events when you don't even think you are. So many people want to give away while they're living. So now I'll flip back to where we were. We were on page 10. Let's now talk a little bit about the creation of the life estate interest from a gift and an estate tax situation, as well as with a step up in basis situation. So what happens when you gift away the remainder interest and retain that life estate? You have in fact made a completed gift for gift tax purposes. And you would need to be required to file a 709 gift tax return. So back to our example in A above. The proceeds are $156,000, $156,437 is the remainder interest value of the property that we gave away. Well, that would be the amount you need to report on the gift tax return. Well, good news is it's way less than the $5,450,000 gift tax exemption for federal purposes, so we're not going to have a federal gift tax. Arguably, it's certainly more than the $14,000 present interest exclusion that we're allowed to give away, but we don't believe it would actually qualify for that anyway, because it's really a future gift. Okay, they can't possess it right now. But nevertheless, in Massachusetts, there is no current gift tax. So we would not have a gift tax to be paid, but you would still need to file that gift tax return.
Just a practice pointer, I think out of 100 of these types of transactions, 100 will not file a gift tax return.
That is true.
As a practical matter. There isn't any penalty for failure to file unless the value exceeds the exemption amount. And you're going to hear in a minute that the property is includable in the estate anyway. So yeah, we have technical requirements, but I can tell you no one's going to pay you to file a gift tax return for something like this. So I just, again, the practical side versus the legal side.
Very good point. And again, the good news is there won't be any tax due anyway. Now, what about the estate tax side, right? We have to look at all the components. Well, in this case, we're going to talk about Code Section 2036, because that's really what comes into play here. again, having transferred the remainder interest away and retaining a life estate, 2036 says that while, well, from a gift standpoint, you've made a completed gift, they're saying you really didn't. 2036 says that when you give something away but retain the right to either enjoy what it is that you gave away, ability to live there, or retain the income or the ability to control what you gave away, then you didn't give it away. And so the value of that property would be included in the estate and not just the life estate value. We've gone out of our way to show you the difference in value between the life interest and the remainder interest, but the full value of the property would be included under 2036 in the estate. Now, while that sounds bad, there's some good that can come from it. But let's look at the estate tax ramifications first of that inclusion. Well, we have a $5,450,000 exemption for federal purposes. I don't know what the rest of this individual's assets are, but even if we were to make the value of this property, and I want to bump it up to make it more interesting, let's go back to this property being worth $1 million, like we used in a prior example. Even if that whole $1 million gets included in that person's estate, unless they have a whole lot of other assets, it's likely they're going to not have a federal estate tax problem. So good, no downside from the inclusion federally. However, here in Massachusetts, we have a $1 million exemption, and as we know, when we go over that exemption, we pay tax on the full amount, not just the amount over, but the full amount of the value. So in this case, if they have that one asset of $1 million, likely they might have a few other assets. They could be over, and there could be some tax due in Mass. But I'm still not convinced that that's a problem, right? Giving it away is not the best idea here, because even if we had an estate of $1.5 million, the $1 million of the house and $500,000 of other assets kicking around, the Massachusetts tax would be about 60 grand, give or take, on that estate. I want to contrast that with what would happen if we gave it away. And this is where we bring in our step up in basis discussion. So if in fact we had given away this property and did not retain a life estate, did not live there, really just walked away from it and died, yeah, the Massachusetts estate would only be $500,000 because we gave away the $1 million. But of course we would have no exemption left because we would have used up our entire Massachusetts exemption on the gift, and so we would have to pay tax on the $500,000. Again, a small amount. But when the kids would then go around to sell that property later, let's assume zero basis just to make it easy. There would be a carryover basis in the hands of the children, and then they would sell it because most of the kids don't want the property. They want to get out, they want the money and educate the grandkids, what have you. $1 million minus a zero basis would equal $1 million of gain. We'd be looking at 20% federal, 5% state, and likely 3.8% Obamacare tax. You're pushing 29%. $290,000 in tax would be due when you sell it at the income tax level. If I keep it and it's included under 2036 in the estate for estate tax purposes, we get the full step up in basis under 1014A of the code because it's included. The kids would then go to sell the property for $1 million. With $1 million basis, capital gain zero, we save $290,000. The flip side is we'd owe Massachusetts about 60. Who cares, right? Pick your poison at that point. So it's all about the basis and looking at that, not just making gifts. Why? Because the government says you can, because you can give away $5 million and change and not pay a gift tax. Not always the best thing to do.
Yeah, the estate planning has really become basis planning. The government gives you this $5,450,000 exemption. And I almost have this vision of all these people in a nursing home who don't have any assets, somehow assigning, I don't want them to die without using it. I'm trying to think of a way that we could use their exemption, you know, by giving them a power of appointment. That's a bit of an exaggeration, but you know, the step up in basis is powerful. Two comments. One is, If there's a retained life estate, the property is includable in the estate, there's no question. The other cases would be if the property had been transferred to the children with no legal life estate, you'd still like to have it included, and what you're looking for in that case is to see if the parents actually ever paid any rent. Because back when the federal estate tax exemption was only $600, the government was always looking to see if they could include these property transfers. And to keep that property out of the estate, the parent would pay rent. But 9 out of 10 of these, the parent is paying the property taxes. Nobody remembered it was even gifted. They're probably deducting the property taxes. That was a really bad set of facts 10 years ago. Now it's like the greatest set of facts on the planet, because we can use offensively against the government to get a stepped up in basis what they would normally be collecting in estate tax. The other question that comes up, Todd, is husband and wife transfer the property to their kids and they reserve a life estate or a joint and legal life estate. I mean, one thing REBA probably should do is to come up with some verbiage. I'm going to talk about some bankruptcy cases where the court hasn't even been able to figure out whether it's a life estate or not. But if a husband and wife transfer a property and reserve a life estate, the question is how much is includable on the death of the first one and the second one. And I happen to find a case, which is at the bottom of page 11. The Glazer case said, let's say when the husband dies, only half is includable. Now, that was good news back then because the exemption was lower. It's not such good news today because you'd like to get the full step up in basis, but Glazer is still law. The theory is that the father who died had only the ability to transfer his half, and so only one half of the value would be includable in the estate. I guess, should I turn to the legal liability?
Yeah, I
Let's
think
go
that
to
would be
page
great.
12. We're doing really well on schedule. And this is the legal liability. The question is, okay, we're going to transfer the property to the children, reserve a life estate. What if the life tenant has a blowout party on the second floor unit in Somerville and they haven't quite fixed the porch and 2 people fall to their death? Well, we know that the life tenant has the responsibility for repairs and maintenance, but what is the exposure of the remainder men children who may or may not even know that they were put on the damn deed? And I found an old case way back, I don't know what year it is, 1990 I guess it was, where it basically said that the remainder men have no legal duty to either the life tenant or to the third parties. This was a case where the remainder men were exonerated from liability. But if the property's insured, I think we're going to be okay. But again, I don't really like the idea of having a remainder interest in my name with my parent with a life estate. We're going to talk about bankruptcy and bad days that we have. Now, a life tenant owes a duty to the remainderman not to commit waste. And I'll give you a set of facts that's making its way through the Superior Court system as we speak. You'll love this one, Todd. I don't think I told you about this one, but this is, this is a Mass Health resident. She's in a nursing home. She had transferred the property to basically the children, I'll say the children, although there's a charity involved, and reserved a life estate. And nobody has kept up the property. It's fallen into disrepair. And by statute, this is at the bottom of page 12, a life tenant owes a duty to the remainder person to prevent waste. You got to make ordinary repairs and maintenance. Well, what's interesting in this case, actually the remainderman was a charity. The charity went to court, and the court issued an order that the life tenant had committed waste and terminated the life estate interest. And then they put the property up for sale, and Mass Health has come in and said, wait a second, you may have terminated the life estate, but there's a life estate value, and we want our money. And the charity is taking the position that The termination of the life estate is an extinguishment of it, and therefore when the property is sold, all of the sale proceeds go to the remainderman and nothing to the life tenant. So I don't know how that's all going to come out, but you can see how
Well, what I would take away from that too is, and I can understand Matt's health position, not that I'm trying to defend it, but what they're simply saying is that even if none of the proceeds go to the life tenant because it was in fact extinguished, then if I were Mass Health, I would say, well, then you made a transfer of the life estate interest and did not get fair market value in return. Therefore, you're disqualified for Medicaid under the disqualification transfer rules.
You intentionally committed waste. And by intentionally committing waste, you've made a transfer.
Yeah.
This is why we get along so well. Can you imagine us talking about this in a bar after work?
I have water right now.
Is he excited or what? No, anyway, we're going to go to page 13. This is the homestead exemption. We had a major revision in 2010, and the legislature included in the list of owners life tenants, but it did not include a remainderman. And so as it sits today, a life tenant can put a homestead on the property, but the remainderman cannot. There's legislation pending, I mentioned this at the beginning, that there's homestead amendments introduced almost every week. But the definition of an owner under the proposed legislation would include remaindermen as well as life tenants. But it's not law yet. We'll go to the top of page 14. You know, what else do we have with life estates? This is the right to partition. So we're going to put this in perspective. The property has been transferred to the children. The parent has retained a life estate. Children don't always do what you want them to do, and that may be another reason not to do a transfer to the children and retain a life estate, but a transfer to a trust with a limited power in the trust document to basically cut out a child that doesn't do what you want the child to do. Well, the question is, can a remainderman petition to partition? You know, I've had it with mother, I've had it with my siblings, I want my money. And the answer is no. Chapter 241, section 1 says that only a person with a present possessory interest has the right to partition. Now, I know this not because of the research, but because I got my butt thrown out of court. Having gone to court with a remainderman who wanted to sell the property. We kind of knew what the statute said, and but that's the law. A remainderman does not have the right to petition. Life estates and remainder interests in bankruptcy. When you're in our business, you read bankruptcy cases, and it seems like 50–60% of them deal with homesteads. Well, the case here deals with Hajar, and what's interesting in the bankruptcy court is they're struggling with what exactly is it that was created. And when you are dealing with this issue in a bankruptcy, you have a trustee who wants to sell the property, and you have a debtor who doesn't want the property sold, essentially. So what's interesting, just a good example, is this Hajar case. 2007. What you had in Hajar was a transfer of property to these three individuals. We'll call it Joe, Barbara, and Lorraine. Joe Hajar was the deadbeat son who had financial problems. And so Joe had to file for bankruptcy. The trustee wanted to sell the entire property to satisfy the creditors of the 1/3 remainderman. The trustee took the position that since the deed granted the fee to the three individuals and then reserved a life estate, that the life estate was invalid because you gave away the darn property before you reserved the life estate. Again, you can see the battle that rages. Now, the good news is the bankruptcy judge said, no, we're going to construe these favorably, And so the fact that the property had been conveyed with then a reservation of the life interest, or the grant of the life interest, did not deprive the life tenant of the life interest, which was good insofar as Hajar is concerned. So the first thing is the drafting, and the bankruptcy courts they love editorializing. Like, this clearly was not a very effective draftsman, on and on. So maybe one thing Reva should do is to develop a form that we could make as a standard. These are the types of things that we will do. So, but on page 15, what the bankruptcy court wanted to do was to go after the 1/3 remainderman's interest, which was clearly an asset of the bankruptcy estate. But, of course, unbeknownst to me being a tax lawyer, the bankruptcy code provides that a trustee can sell not just the 1/3 remainder interest, but can sell the entire property under certain circumstances. Now, in this case, the remainderman, I should say the life tenant and the other remainderman lucked out because the bankruptcy court looked at the authority in the bankruptcy code, and so the trustee could only sell the entire property if the debtor's interest was a tenant in common, a joint tenant, or a tenancy by the entirety. And since this statute did not include remaindermen, then the trustee was unable to sell the entire property. There was nothing, however, to prevent the trustee in bankruptcy from selling the 1/3 remainder interest for whatever the heck. Again, property interest. But this was a case that was favorable, really, not so much to Hajar, the deadbeat 1/3 remainderman, but to the life tenant. The judge clearly didn't want to throw the life tenant out and have the entire property sold.
But what I think it really does do, Leo, is it emphasizes that fact that, it's comparing a remainder interest, property interest, to a life, to those joint tenancy by the entirety again.
Couldn't agree more. There's
Right
so
there.
much about, when you read all this, you have no conclusion other than a life interest is a property interest. But, at page 16, this is a comment at the very top. The court noted that the will was not a work of an accomplished conveyancer, and that the testator did not use the classic formulation of a life estate. By the way, life estates are not always created by deed. They can be set up in the will. Mortgages. At one time, we did quite a few reverse mortgages. At one time, all that was necessary to have a valid reverse mortgage was a life interest in the property. In fact, one of the coolest things was putting a reverse mortgage on a piece of property, then transferring the property to the kids and having the parent reserve a life interest. You get the stepped up in basis on death, the value of the individual's ownership interest goes down so that you don't go over the $825,000. As a matter of fact, if the property is sold, the life tenant is only entitled to the life tenant's piece, which may even be less than the mortgage. Well, you can't do that anymore. There's a federal regulation here. A mortgage must be on real estate held in fee simple or on a leasehold, etc. But whatever exception there was years ago for life estates no longer seems to be in the regs. A couple of more points. This is on page 16. This case comes up, I believe this is also out of Worcester. This is a legal malpractice case. It has nothing to do with bankruptcy. Facts are pretty straightforward. Individual, older person, concerned about long-term care planning, consults with an attorney. The attorney says, go ahead and transfer the property to the children. If you keep a life estate, it would be subject to estate recovery. Turns out that was a mistake, at least based on the law in effect at the time. Nobody's trying to throw this woman out of the house, but she decides to sue her lawyer for legal malpractice. And for those who do trial work, juries can do anything. The jury finds against the attorney for several $100,000. for breach of duty. The failure was to advise the woman to retain a life estate. What could that? Well, what I like is this on page 17, and by the way, this went from the Superior Court to the Appeals Court, and the judgment against the attorney was upheld. But the court determined that the mother was deprived of a property right. You know, I love this full circle. We start with the Daly case that somehow the life interest is an interest in trust, yet basically the same court determines that the mother was deprived of a property right. A life estate, and that the value of the property right lies in, among other things, it gives one to possession and the free alienation of the property. So that's the Brissett case. Legal malpractice, you just live in fear all
That really
the time.
brings it full circle. I mean, how do you say it's a property right on one day and not a property right on another day?
Yeah, or, I mean, I don't know that it's completely wrong to say that it could be subject to estate recovery. You know, we're facing that now. Anyway, current developments. What are people doing now? Well, we are no longer keeping a life estate in the deed. We, as a firm, are transferring the property to the income-only trust. There's enough in the trust to get the step up in basis. We are developing a lease, which is kind of absurd because the trust says all income goes to the grantor. So if the grantor is paying rent, you pay the bills and the rent goes back. But we feel like the Daly case is the law, that we're just not comfortable with a life estate in the deed when we transfer the property to the trust. What are other people doing? Well, on page 17, the first item is called a ladybird deed, which we don't use in Massachusetts. What is a ladybird deed? A ladybird deed is a deed to the children reserving a life estate, but reserving the power to sell the entire property. Once again, MassHealth deals with this directly. On page 17 at the bottom, 130 Code of Mass Regs 520. If the language of the document creating the life estate explicitly states that the owner of the life estate has the power to sell the entire property, not simply the life estate, then the creation of this type of life estate will be treated as a trust. You know, express inclusion, implied exclusion. I forget the Latin for it, even though I am a Latin school guy. But that seems to say that it's a life estate. And we have a question? Mm-hmm. Let me conclude and then we'll answer some questions. And then on page 18, this is where practitioners are transferring property to children, but in the deed itself, they're reserving a limited power to change the final designation. So I convey by quitclaim covenants the property to my two children, but I hereby reserve the right to change the grantees. And as I say this, and I go to these REBA meetings, I can almost feel the pain in terms of conveyancing. What is it? You know, those should be accompanied by something that says, you know, provided that if the reserved right is to change it by will, you know, it ought to be something about the will has to be filed to probate within 60 days or something. So there are practitioners, we're not using ladybird deeds, but there are practitioners that are recommending a deed with a retained life estate with a reserved limited power. Once again, I think REBA will look at this a little bit closer now, that this has become more of a practice of practitioners. So, our conclusion is that we are certain that a life estate is a property interest. Todd, you have a question, do you?
We do.
Mm-hmm. You can read that out.
It says here that, is there any circumstance where an outright gift of property could escape taxation in Massachusetts if the estate would otherwise be taxable in Mass?
And let's preface this by saying this is not a life estate question. This is what is the effect of a gift in Massachusetts on the mass estate tax? You know, when people use the word tax, I think they're referring to the estate tax.
Yeah, it says otherwise the estate would otherwise be taxable. Yeah, it's an estate tax.
And so, Todd, why don't you give the example of, we're gonna assume property that's worth, I'm gonna use $5 million. Let's keep it real simple. Property on Nantucket. If that person dies owning the property, a single person, and let's assume zero basis, which may not always be the case. When that person dies, there is no federal estate tax. The kids get a stepped up in basis equal to $5 million, so when they sell it, there's no capital gain. If that property, well, I should say, before we get there, there would, however, be a Massachusetts estate tax equal to $5 million, subtract the $1 million exemption, $4 million, and multiply it by roughly 10%, 400 grand. Todd made this point earlier. If that property is gifted with no retained life estate and is not includable, there is no step up in basis, but there is no mass gift tax and there is no mass estate tax. They save 400 grand. That can be done the day before death, by the way. The problem is that when the kids turn around and sell it, their basis is 0, carryover. The sale price is 5. Multiply that by 30%, that's $1.5 million in capital gain taxes for the reason to try to save $500,000 or $400,000 in mass taxes. The question is a great question. So yeah, it's real easy to avoid the Massachusetts estate tax, but you better be careful about what the property's basis is, because it's like legally laundering money with this new $5 million, $450,000 exemption.
That was the only question. So,
Oh yeah, a couple of questions in the audience here.
go ahead. We'll start and we'll go around.
You've been focusing in your examples on single-family homes. What do you do about a two-family, but where the Medicaid applicant, if you will, lives in floor 1, leases out floor 2, retains a life estate which includes the right to collect the rents, pay the bills, at the same, and conveys out the remainder interest?
I can do. So the question is, how do you deal with the two-family, in Southie that you've got with the renting the upper floor and living in the lower floor, and it's on one deed? Well, if we're going to reserve, and if you want to reserve the life estate, how do you do it? Well, if somebody, again, we're now not reserving the life estates, just for the record, we would have transferred the entire property to the irrevocable trust, with the trust itself saying the income of the trust needs to be paid back to the donor. Okay, so there's the ability for the trust to collect the rent and then pay it right back to the donor. So they don't actually need the life estate to continue to collect the rent. So that's how we would do it going forward. But if there's an older one out there where we would have reserved a life estate and transferred the remainder interest in the property, same result, right? How would it work out? Instead of during the life of the life tenant, the rent would now not be deposited into the trust if that's where the remainder interest was put. But it would go right to the life tenant, because by definition today we said that a life estate, right, you have the right to use and occupy, but you also have the right to the profits from the property. So the rent would just be deposited directly into the personal bank account of the life tenant and would completely ignore going to the remainderman, which would be the trust in this example.
Everything else would stay the same.
Everything else would be the same.
That would still be considered a home.
Yep.
The fact that it's a two-family, a three-family.
But coming back to the case, the Daly case out of Worcester, if the life tenant is enjoying the income from the property if there's a compulsory payment of income to the life tenant, as long as she lives in the property, doesn't that support the Daly decision that in fact she is a beneficiary of the trust?
No, I'll try to address. I mean,
Absolutely.
So the question is, does does the fact that in Daley, there's a life estate in the deed, and they're getting the income from that property, doesn't that make them a beneficiary of the trust?
No, I'm saying if you convey the remainder interest to the trust.
Yeah, yeah.
Yes?
To a irrevocable trust.
Got it.
And the trust has an obligation to pay the rent back to the life
Oh.
beneficiary.
So is there a life estate in this question or not?
There is no, there's an obligation under the irrevocable trust.
Oh, okay, so they
to pay the
didn't-
income back to
Got
the Medicaid applicant.
I got it. So there is no life estate in this question. It's,
No.
the question, if I can rephrase it, is that the entire property was transferred, it's a two-family, was transferred to the trust, irrevocable income-only trust,
Well, I think he.
and no life estate?
Yeah,
Is that-
just some trouble.
Oh, no, she can reside in the property.
Let me just stop. So the property is being transferred to the irrevocable trust.
Correct,
The trust provides that income is payable to the grantor.
to the grantor, correct.
The second sentence says the grantor shall have no access to principal under any circumstances whatsoever forever.
Correct.
The trust pays the income to the grantor. That is correct, but the income is considered countable, and that's why we're breaking down. So when we use income only, we're distinguishing, the regulations say that the trust assets are countable, but only to the extent of either income or principal. So there's nothing inconsistent with having the income go back to the settlor on your facts.
But the income is countable.
For sure.
For sure.
It's
For
only
sure.
the principle that we have protected.
For sure.
For sure. And to tie the loop, in order for the trust assets to be considered available, and I'll read this, property in an irrevocable trust is countable when it is available according to the terms of the trust. When you have a life estate, your right to the rent, your right to possession is not according to the terms of the trust. In fact, the trust says you can't have it. The question.
And that's where
we want-
Daley really.
We want to get this question down. Thank you very much.
Just from a conveyancing standpoint, if you do that conveyance to the kids, and then the parents die,
Parents
and record
die.
your death certificate, you also need an affidavit that there's no estate tax lien?
You would need an affidavit of no federal estate tax lien, and you would also file a death certificate. And if Mass Health has its way, you're going to have to send a notice to figure out what the claim is, even though it's a non-probate asset. But right now, you file the death certificate and the affidavit of no estate tax filing requirement. Good.
The Daley case, it's a Superior Court case, isn't it, on appeal?
The Daley case is a Superior Court case where a motion to reconsider was denied. The briefing for the motion for reconsideration, the judge didn't take too kindly to it. I think a decision was made within the elder law community to persuade them not to appeal. Because if it becomes an appellate decision, there's a likelihood that the appeals court would just upheld what the Superior Court did, and that's kind of scary. So it is not under appeal. I don't think it's going to be appealed, and we would discourage it.
And I would add to that only that the biggest thing is that this trust in Daley is bad in other ways. Okay, it's the life estate piece that we don't like
Right.
in the decision, but there are about 3 other paragraphs in that trust that would probably cause the trust assets to be countable for Medicaid anyway. So you're not going to get a win on appeal. You would just hope that they would say, with regard to the life estate piece, we were wrong, but with regard to these other 3 bad paragraphs, we're not going to change our mind. So you're not going to get a win on appeal anyway.
But you gentlemen think that that's going to be continuing to be the law. And
It's
that's why
yeah.
we're
I
avoiding
think
the
you
life
need
estate now.
people like us to start writing articles and get them published, and then the next Superior Court judge. I'll be honest. Todd has had a number of cases where there were life estates in the deed, identical set of facts, and we won. There was not an issue. The problem in this case is there was enough in the trust itself to draw the judge's attention, and what do they say? Throw the baby out with the bathwater? Basically, so, yeah,
Question,
question.
if you have one of these trusts where you have reserved the life estate, and now this is Now, you don't think you should have the life estate anymore. Can you extinguish the life estate, and does that trigger another look-back period?
It's a great question. The question is, okay, Leo, you did a lot of life estates over the years. Are you now extinguishing the life estates? That would be a further transfer with a 5-year look back, and we internally have made a decision not to do
Probably
anything
not
yet because it
financially.
was the law at the time, and we still think if we can have a trust that is pushed through and there's nothing really wrong with the trust, I don't think they're going to deny us because of the life estate. But these are things that we hope to accomplish through this committee. One last comment. Trying to find hot topics, but the next conference we have is going to be on June 9th, and this one is going to be entitled, what is it? A Single Member LLC, a Property Interest, or an Intangible. Now, what the heck does that mean? Can you put property into a single member LLC, sell the membership interest, and avoid paying $456 per thousand? Second big area is people who move to Florida for estate tax purposes, they can't keep their Massachusetts property. They need to convert the Massachusetts property to an intangible. New York just came out and said a single member LLC is property. It's not an intangible. Mass probably won't be far behind. So it's going to be a compendium of cases. What are we going to do about moving people out of state? And there is a property interest because you'd like to avoid paying $4.56 if you possibly can. Anything else, Todd?
No, I think
Well,
we've
like
come full
frickin'
circle.
frack, we love this stuff. Thank you all very much. Anybody who's listening online, if you want to become more active in the committee, please do. We have a lot of things on the agenda. Thank you all very much for
Thank you.
attending.